Today, we're diving into a crucial piece of the law, Rule 85 of the Rules of Court. We're calling it the Administrator's Playbook.
Welcome to LexAI, your AI-powered partner in mastering the law. We combine artificial intelligence, legal analysis, and jurisprudential insight to make complex legal doctrines clear, visual, and easy to understand.
So, imagine this. You've been named an executor or an administrator. That's not just a title, it means you are literally holding someone's entire legacy in your hands. Rule 85 is your roadmap. It's the guide that tells you your duties, how you get paid, and where the liabilities are. It's your map, for sure, but it's also a big warning sign for all the potential pitfalls.
In this explainer, we're going to break it all down. We'll kick things off with the foundational duties and liabilities, the real core of the job. Then we'll get into the nitty-gritty of handling the estate's money. After that, we'll walk through the all-important accounting process, and finally, we'll wrap it all up with a quick-glance summary and the key takeaways you absolutely need to know.
First up, let's talk about the absolute fundamentals, Sections 1 through 5 of Rule 85. Think of these as the ground rules, the fundamental rules of engagement that lay the groundwork for everything else an administrator does. This is the heart of what we call the fiduciary's birding.
Section 1 does not mess around. It makes it crystal clear that the administrator is personally on the hook for everything. We're talking the entire estate at its official appraised value, every bit of income it generates, whether that's rent, interest, you name it, and of course the actual cash that comes in from any sales. There is absolutely no hiding. Every single peso has to be accounted for.
Now, this brings up a really critical question, doesn't it? Let's say an asset in the estate, maybe a piece of real estate, goes up in value while the administrator is in charge. Can they just pocket that extra profit for themselves?
And the answer is a hard no. This really gets to the core idea of Section 2. The administrator is a trustee, a caretaker. They're not an investor trying to make a personal gain. Any increase in value, that belongs to the estate, period. Now, on the flip side, if an asset loses value and it genuinely wasn't their fault, they aren't held liable for that loss either.
Okay, so what about debts that are owed to the estate? Section 3 gives the administrator a little bit of a shield. They aren't automatically held accountable for debts they couldn't collect, but, and this is a huge catch, they have to prove that the failure to collect wasn't their fault. If they were negligent, maybe they just let a debt prescribe and didn't do anything about it, well then they become personally liable for that money.
Let's think about another practical scenario here. Say the estate includes a house. Can the administrator just move in and live there, rent-free, while they're settling everything?
Once again, that's a firm no. Section 4 is very clear. You cannot use estate property for your own personal benefit without paying for it. The administrator has to pay the estate the fair market value for that use. They can either work out an agreement with the heirs, or the court will step in and set the amount. It just reinforces the idea that the estate's assets are for the beneficiaries, not the administrator.
So what happens when an administrator drops the ball on these duties? This is where Section 5 brings in a key legal term, Devis debit, which is basically a fancy word for waste. This could be anything from negligently failing to collect debts, like we just talked about, or, improperly using estate property without paying rent. Any negligence or unreasonable delay that causes the estate to lose value is considered waste. And the most important part, the administrator is personally liable for that damage, and their bond can be tapped to cover the loss.
Okay, so now that we've covered the core duties and the pretty serious consequences of failing them, let's shift gears and talk about the practical side of things, handling the money. This part covers two really important areas: how you manage costs and, of course, how the administrator actually gets paid for all their hard work.
Litigation is often just part of settling an estate, but the big question is who pays for it? Section 6 says that legal costs can be charged to the estate, but only if the lawsuit was fought in good faith and for a just cause. An administrator can't just decide to fight frivolous legal battles and expect the estate to foot the bill. So how does the administrator get compensated? Well, Section 7 provides a very clear statutory formula. As you can see here, it's a tiered percentage system based on the value of the estate. The court also has the discretion to allow a bigger payment for estates that are particularly large or complicated, which makes sure the compensation is fair for the amount of work that's actually involved. Now, Section 7 also includes a critical rule, especially for lawyers. If the administrator also happens to be a lawyer, they cannot double dip. They are absolutely entitled to their administrator's fee, but they cannot then turn around and charge the estate separate professional legal fees for the work they do. Their compensation is strictly for their role as a fiduciary.
And that brings us to the final critical stage, accountability. Sections 8 through 11 lay out the entire formal process of accounting. This is where the administrator has to prove to the court and to everyone else involved that they've managed the estate properly and by the book.
Section 8 sets some very strict deadlines. As you can see from this timeline, that first formal accounting is due within 1 year of being appointed. After that, the administrator has to keep submitting accounts whenever the court orders them to, all the way up until that final account is submitted when the estate is totally settled. And yeah, missing these deadlines is a big deal. It can even be grounds for removal.
But just submitting the paperwork isn't enough. Sections 9 and 10 require a formal hearing. First, everyone who has an interest in the estate has to be notified. That's just basic due process. Then, at the hearing, the court puts the administrator under oath and questions them about the account. It's an open inquiry, so heirs and creditors can also be examined. The whole point is to ensure total transparency and accuracy before the court gives its final approval.
Finally, Section 11 recognizes that there's another key player, the surety. That's the company that provided the administrator's bond, and they are financially on the hook for any mistakes the administrator makes. So it only makes sense that the surety has the right to participate in the accounting process. They want to protect their own interests and challenge any improper charges that could end up costing them money.
Okay, let's pull all of this together with a rapid-fire review. Section 1. You're chargeable for everything. Section 2. No personal profit, no personal liability for losses without fault. Section 3. You're only liable for uncollected debts if you were negligent. Section 4. Use estate property, you pay fair value. Section 5. Negligence that causes loss is waste, and it's on you personally. Section 6. Litigation costs are covered, but only if the case is in good faith. And finally, Sections 8 through 11 spell out the whole formal process: accounting, examination, notice, and the surety's right to be there. So, what are the absolute key takeaways you need to remember from Rule 85? First, and most importantly, an administrator is a fiduciary, a trustee, not an owner. Their job is to protect the estate, not to profit from it. Second, accountability is total. Every single peso needs to be accounted for. Third, negligence that causes a loss is called waste, and it leads directly to personal liability. And finally, remember that the accounting process isn't just bookkeeping, it's a formal court proceeding. So in summary, this topic teaches us that the role of an administrator is one of sacred trust, governed by a strict duty of loyalty and care.
And to help you lock in all 11 sections of Rule 85, here's a final study tool for you. A simple mnemonic: CNURNLFANS. That stands for charge, neutrality, uncollected debts, reality use, neglect, litigation cost, fees, accounting, examination, notice, and surety. It's a really powerful way to master the administrator's playbook and remember all the key responsibilities that come with this incredibly important role.